Bueno, os damos la bienvenida a todos en esta entrevista, en este caso a Stephan Kinsella, que es un abogado y jurista estadounidense, fiel colaborador de Hope en sus conferencias de la PFS, la Property and Freedom Society, conocido sobre todo por su famoso libro Contra la Propiedad Intelectual y muy reconocido en los ambientes anarcocapitalistas contrarios a la propiedad intelectual.
So anarchism, I would say anarchism is the most consistent form of libertarianism. I would still consider libertarians in general, like minarchists, which you could call the minimal state libertarians. I don't think they're fully consistent. They're far more consistent than a conservative or a classical liberal because they reject most functions of a state, but they still believe in a core function of the state, which is a little bit inconsistent with their opposition to aggression and their belief in private property rights. So I would say the most consistent libertarians are anarchist libertarians. And by the way, I would not include in that non-libertarian anarchists. I don't really consider like socialist anarchists or non-libertarian anarchists to be true anarchists, because in the end, if you're a so-called anarchist but you're not a libertarian, that means that you actually believe in the institutionalized invasion of private property rights, which basically implies the state. So you really can't have a true stateless society if you don't have libertarian anarchism. So that's how I look at libertarianism in its relationship to anarchy.
Yeah. The second question is this one. So I would like you to define aggression and its opposite, which would be the contract. What does a theory of contract need to have? Are voluntary slavery contracts valid?
Okay.
And why?
Okay, so as I mentioned earlier, I view property rights as fundamental and primary. Aggression is more of a consequence. So for example, we don't say that we have property rights because it's wrong to commit aggression. What we say is that because property rights are justified and legitimate, it's wrong to violate those property rights. And that's what aggression is. Aggression is the unconsented to use of someone else's owned resources or property, whether it be their body or other resources that they own. So if I use your car without your permission, that is a type of trespass or theft of my property. If I hit your body without your permission, or if I shoot your body with a gun without your permission, that is also using your resource, your body, without your permission. Now, we typically would call that second activity aggression, because aggression means hitting someone. So if you oppose aggression, it's the same thing as saying you support property rights in people's bodies. It's just another way of saying it. Now, if I use your car without your permission, that's not technically a type of aggression, because it's not aggression against your body, but it's still a violation of your property rights. But we kind of use the word non-aggression principle, or as a shorthand to encompass the view that property rights are violated by the lack of consent. So basically, every human being is viewed as an owner of their body and owning other resources that they acquired peacefully from a previous owner or from the state of nature. And that ownership right gives you the power to exclude people from using it, or to deny them the right to use it, or to permit them to use it. If I allow you to borrow my car for a day, that's perfectly fine, because I'm the owner. And if someone is using the car with my permission, they're not committing trespass because they did it with my permission. If I withhold permission and they use my car anyway, that's a type of theft. But so it all depends upon the consent of the owner, which is what contract is, right? So as for voluntary slavery contracts, I view that the right way to look at contracts is not the conventional way that the law and most people look at it. The conventional way that contracts are viewed is, and I discuss this in chapter 9 of my book, where I discuss the different view of contracts of Rothbard and Williamson Evers, who have a different theory of contract, which I think is a sounder theory of contract and more compatible with libertarian rights and with private law. The conventional way, the typical way that contracts are viewed is that it's a promise someone makes that other people rely on, that gives the other person the right to expect you to perform what you promised to perform. And if you don't perform it, then you're in breach of contract and you owe some kind of damages to the other party. I think that's and the problem with that view is that it leads to this dilemma about what types of contracts should be enforceable, and should voluntary slavery contracts should be enforceable. If you view contracts as simply, as I said before, every human being has property rights in their bodies and in other things that they own. This property right gives you the ability to permit or to exclude others from using your resource. Using that power, you can actually permit other people to use your resource, and you can make a contract, which means you transfer some of your resources to someone else. You give it or sell it to them, right? So having an ownership of a house or a car means I can give it or sell it to you. And once I do that, now you own that resource. It's not some kind of mystical, magical formula that I'm doing. I'm not waving a magic wand. I'm simply using my power as owner to transfer it to you. So you don't even have to look at it like a binding obligation that the law enforces. The law's job is only to recognize who owns what resource, and that's what property rights are for. The property rights that I mentioned earlier help us identify who owns what. So if someone wants to hit my body without my permission, the law would say they can't do it because the law identifies me as the owner of my body and not the other guy, right? Or if someone wants to take my car without my permission, the law says you can't do that because I'm the owner of the car, because I bought it from a previous owner and I have a chain of title which could prove that I own it. So every conflict like this can be solved by property rights identifying who owns what. It doesn't require there to be binding obligations. So if I transfer to you my car and you transfer me some money to pay for it, then the law of property rights would identify the buyer of the car as the new owner of the car. And then I wouldn't have the right to it anymore because I gave that right up by my contract. So that's how Rothbard and Evers view contracts, as simply the power of disposition of an owned resource to someone else, but not as a binding promise or obligation. So you never have this idea that if I promise to be your slave, the law can enforce that, because law is not about enforcing promises. It's only about recognizing who owns what. So then the question is, well, so a slavery contract would not be, so here's the way I look at it. Why aren't slavery contracts enforceable? Like you could say, like Walter Block argues, okay, let's say it's not a binding promise, but let's say that I own my body, so I'm selling my body to you, right? Like if I own a car, I'm selling my car to you. The mistake with that reasoning is that it fails to distinguish the difference between the nature of our ownership of our bodies and the nature of our ownership of acquired resources, and also the basis of these rights. So as I mentioned earlier, the reason that each person is a self-owner is because every person, well, I didn't mention it, but it's in my book, and this is Hans Hermann Hoppe's theory. The reason that you have, the reason aggression is wrong against my body is because I own my body. The reason I own my body is because I have a better claim to it than anyone else. It's not because I acquired it by homesteading it from the state of the world, because that would make no sense. I don't have a disembodied soul or something walking around acquiring an unowned body like I would acquire an unowned piece of land. To acquire an unowned piece of land, I have to already have a body that I control. So the basis of my property right in my body is because I have direct control over my body, giving me a better claim to it than anyone else. In the case of unowned resources, the reason I have a title to this piece of land or to this car is because I have a better claim than anyone else, because I acquired it from the state of nature and I was the first one, or because I bought it by contract from a previous owner. So that's the basis of ownership of external resources. It's not the same thing as the basis of your body. And so The reason I can transfer my car or my home to you is because it was at one point in time unowned, and then I acquired it, and now I'm the owner. But when I acquired it, it means I can unacquire it. I can abandon it. I can give it to you and get rid of that time. It's not. But on the other hand, if I simply say to you, I hereby give you my body, I'm not committing an act of aggression against you. So there's no reason I can't change my mind. And if I change my mind, I haven't committed aggression. So you have no right to compel me to perform, because the fact remains that I still have direct control of my body. So I'm still the natural owner of my body, whereas I'm not still the natural owner of a resource that I abandoned and gave up to you. So the reason that you cannot enforce a voluntary slavery contract is simply because it would be an act of aggression. Remember, libertarianism is a symmetrical doctrine, which basically believes in this consistency that I mentioned earlier, which means we believe in absolute consistency in terms of our rights. If someone commits an act of aggression against me, I have the right to respond against them. I can defend myself against someone trying to harm me or to steal from me. And when I do that, I'm not committing aggression against them, because my action is in response to what they did. Their action is the act of aggression, because it's the initiation of force. It's the use of my resources without my permission. They're the initiator of force, and they're the ones committing the wrong. But what that means is no one can use force against me unless I first use force against them.
Mm-hmm.
And by me promising to be your slave, I am not using force against you. So if I change my mind, I'm not violating your rights. One way to think about this is imagine everyone thinks that you have the right to promise something and not back out of it. But the reason they believe that is because we always go by the last expression of consent, because that's all we can do is use communication and language. So, for example, if two guys are playing American football or boxing in a boxing ring, or they voluntarily enter the ring and they start punching each other, they both consented to the fight. So there's no aggression. There's no rights violation. Now, if one of the boxers changes his mind and tries to leave the ring, he can't be physically stopped from leaving the ring. He can quit, because now he's showing what his new consent is. Like, now if he gets punched, it would be a violation of his rights. Mm-hmm. But that's because the latest expression of your consent is the one that has to govern, because you can change your mind. Just like if you have a man and a woman on a date, and the girl says, hey, at the end of our date, I will let you kiss me goodnight. Okay. And then 2 hours later, he takes her to her door and he kisses her goodnight. If she complained of assault, she would lose, because as far as the guy knew, he had her permission. But if she changed her mind 2 minutes before and she says, I know I told you I would let you kiss me, but I don't think I want to. Now, if the guy kisses her, it would be assault, because the most recent expression of her decision is the one that matters. There's no reason the mistake people make about this voluntary slavery thing is they think that people can't change their minds. You have the right to change your mind as long as you're not violating someone's rights. And that's why voluntary slavery contracts are totally unenforceable, in my view.
Yeah.
Okay, I agree fundamentally with this position, because, I mean, for me, the block position is no sense. I mean, that every promise can be enforceable it leads to a no sense. I mean, for example, in the interview, if you change your mind and you want to leave the interview, I mean, it's a no sense that I can enforce you to stay
Correct.
in the interview.
Same thing, by the way, with people who sign up for the Army. That's the only job, like in most countries, where you can't quit. You know, if I go work for FedEx or McDonald's, I can quit, and they can fire me. But if I sign up for the army, they won't let me quit. If I try to quit, they'll put me in prison. So they do treat us like inalienable, like voluntary slavery contracts are possible. And by the way, again, if you take the Rothbard view of contracts, it's simply the exercise of ownership, a power of an owner to transfer it to someone else instead of a binding contract and legal obligations, then you never have this dilemma. And by the way, it also solves the social contract dilemma, which is, again, people think of contracts as binding promises, and so then they think maybe there's a social contract, even though there's no evidence of this contract. But the point is, it's not only that there's no evidence of the contract. That's not what contracts are. Contracts are not binding obligations. So there could be no social contract which authorizes the state, because that's not contracts are not binding obligations. They're just transfers of title to owned resources, and the state never got those. The state never got such a transfer. It stole the money by taxes or by outlawing other competing agencies and raising prices and forcing people to buy their services from the state. So everything the state does is effectively criminal and illegal.
Yeah, I agree. And another question that is an argument that I saw today is like, contrary to many libertarians, in the moment that we decide to have children, we are responsible and we create like an positive obligation towards them, because create the kid is a voluntary and free decision. What limits could we have with these positions? For example, will teaching minors that transgenderism is good will be a breach of this obligation or not, for example?
I think it's hard to answer a lot of questions in a society like ours, which has lots of laws that have been built up by statist institutions. It's hard to predict what a free society would look like, and it's hard to answer every possible question from our armchairs deductively, especially because we don't have a lot of natural hierarchies and social customs that would have been built up in a more peaceful way. So it's hard to know. My view is this. I do believe anarchy is the right position, and I think individual rights is the right position and the only justifiable position in the end. I think libertarians are reluctant to, so libertarians often say that this means that we only have negative rights, not positive rights, or negative obligations, not positive, which means you just have to refrain from violating other people's rights. But the way they say this is that there are no positive rights in libertarianism. I think that's wrong. The way I would say is there's no unchosen positive obligations or duties or rights in libertarianism. There are no unchosen ones, which means, for example, if you're somewhere in public and you see some person in trouble, like they're drowning in a lake, I think you probably have a moral obligation to try to save them, but you don't have a legal obligation in the sense that if you let them drown, you're not committing the murder. You're not responsible. Absent a special obligation, like maybe you're a lifeguard who is paid to do it or something like that. However, one example I give is if you negligently knock someone into the lake or you push them into the lake and they can't swim, I think now you do have a positive obligation to save them. And if you don't, you might be liable for their drowning. And that's because you caused the problem. Okay, so that's an example of a positive obligation you have, but it wasn't unchosen. It was something that was a result of your action. And likewise, I would say that due to the unique nature of the dependency of infinite human life, babies are not born ready to go like a horse. Because of our intelligence and our big brains, and because evolution, it led to women having to give birth later and later and later, or I mean, earlier and earlier, because the baby couldn't pass through the birth canal. If you waited for it to get mature, like a young horse, it would kill the woman. So women have to have babies when they're still dependent and helpless, so that our big brains can do the job. And so this has led to us being a social species where the infants come into the world much like the guy you push into the lake, right, is in a state of dependency because you put him in that position. And I think that the mother arguably has a positive obligation to take care of the baby until it's, ready to fend for itself in a later age. Now, I also believe that because of the unique nature of the family and the danger of laws that interfere with family relationships, the law should be very, very reluctant to interfere in these things, even if the parents are doing something that's tantamount to child abuse, like the transgender stuff. I would say that a parent doing that to their children, if you have the view that I guess most of us do about the nonsense of transgenderism, I would say it's tantamount to child abuse. But I would still say that the jurisdiction over this should be with the family. So if this family unit basically has a private law that allows for the parents to abuse their children like that, it's horrible, but the outside world shouldn't get involved. I would simply say that at a certain point in time, if you're abusing a child to a certain extent, then the child can run away or be rescued by relatives or something like that. So that's how I view this. I think it's a tricky issue. I also do believe that the age of majority in most Western countries is too high. I mean, if you have a certain age kid who can demonstrate that he's independent and wants to manumit himself and run away, I think he can be treated like an adult, maybe at 12 or 13 years old, if they can prove that they're mature enough. And if they don't want to take the hormones or whatever procedure their parents are consenting to for them, they shouldn't have to do it. But on the other hand, if they want to do it, then I would treat them more like an adult, just like an 18-year-old. I think they're making a mistake to mess with their bodies, but I think it's ultimately their right if once they're at a certain age of maturity.
Yes, but I have a question that is related to this.
Mm-hmm.
I mean, in the case of teaching transgenderism, it's a no sense, but it's not, at least if there is no operation, it's not physical, it's only immoral. But if there is like physical abuse, I mean, this is obviously a crime because the kid is the kid has rights, and physical abuse should be a crime. And I think that the state, in the moment that maintains law, the forcing to follow the state law, should punish the people who abuse physically their kids. No,
you can make that argument. I'm not totally upset with that kind of argument. For example, I now believe that like physical punishment is spanking kids, even spanking kids is close to aggression, but I even think that psychological abuse is also a violation of your obligations as a parent. But we have to be really careful. I mean, look, you could argue that lots of crazy beliefs, like certain religious beliefs and teaching your kid about socialism and communism, you could argue these are all, in a sense, child abuse. But ultimately, you have to devolve the decentralize down to the family unit wherever possible. But when it comes to physical abuse of children, if it's severe enough, I think at a certain point in time, the parents lose their rights over the kid, and the kid can be rescued by someone else who wants to help them out, a relative or some kind of society, or even in today's world, even the governmental agencies which are tasked with preventing child abuse.
Yeah. So let's move to the next question. You found a compelling argument for the libertarian legal theory, which is estoppel. Please, could you explain what this is? And wouldn't it lead to an eye for an eye as long as it's listed to kill or murder someone who has already murdered by himself?
Right. Yeah, let me go into that. So you notice my earlier discussion, I didn't mention like the arguments for rights. And there are many arguments for rights. There are natural law arguments for rights. There are consequentialist and utilitarian arguments for rights.
Yeah.
There are transcendental arguments for rights like Hans Hermann Hoppe's or some of mine. There is one by Jan Lester, critical, I forgot what he calls it, critical something. So there's different approaches to it. I don't think these are all incompatible with each other, like a lot of people think. You have to choose between utilitarianism or consequentialism or natural rights or something like that. I mean, I think that we humans all, especially we libertarians, whatever our basis, we're talking about norms and rights and wrongs and ethics and the way we want the world to be and what values we all happen to have and share as humans, mostly non people that are not psychopaths, but most normal people share certain values for peace and all this kind of stuff, which is undergirds our belief in the practical property rules that we want to see in society so that we have justice. So it shouldn't be a surprise that, I mean, Ayn Rand said that, something like the moral is the practical. And I think that's true because the purpose of property rights and morals is a practical thing to help guide us in the world so that we can achieve our values and live among each other as peacefully as possible in a world of possible conflict and in a world of disagreements, right? And in a world of sometimes conflicting interests. That said, I think that there are some problems with utilitarianism because it is somewhat not with consequentialism. Consequentialism just means, listen, if you share, like Mises was more of a consequentialist. If you share certain basic values that most humans share, like we want peace and prosperity and harmony, if possible, then as long as you understand about how economics works, then you understand and then the nature of politics, then you will say, well, we all share these values. The way to achieve it is to have a free society with property rights being respected and the rule of law, right? It's a means to that end. There's nothing wrong with that. It's just that it's sort of you can't. It's not always 100% consistent. Like then you might make exceptions for the draft and for taxation, but basically it leads in that direction. The problem with natural law arguments that Hans Hermann Hoppe pointed out is that then you're arguing from our nature as humans, what should we do? What rights should we have? And the problem with that is, as David Hume pointed out, is that you're going from an ought to an is. And there's a logical problem there. You just can't go from a logical ought statement to an is statement without smuggling in some secret or ought statement, which just pushes the problem back. So that's one kind of problem with natural law arguments. So Hoppe came up with his argumentation ethics, and which I discuss in my book. And in law school, it occurred to me that there was there's a theory in contract law where the courts will sometimes justify holding you to a promise you made if it would harm the person you made the promise to because they relied on it. Then you would be stopped from denying that you had made the promise, even if you didn't have other formalities you need, like if you need consideration or something like that. Like if there's a defect in the contract, you could usually get out of it by saying, well, I didn't really have a legally binding contract because I forgot to have consideration. Yeah. But the courts in equity would say, well, okay, but in this case, the other guy relied on your promise. And so if you're able to make a defense saying you don't have a valid contract, he would be harmed. And so we're going to prevent you from making that excuse. We're not going to let you assert your defense, which normally you could do. So it's an alternative way of holding you to your promise so that the other guy's not harmed. Now, there are problems with the legal version of that, but the insight there is that you should be held to a consistency in what you say. And although it's problematic in contract theory, the basic insight, I think, it made me think, well, that makes more sense for libertarian rights, because the whole point of libertarianism is that, again, there's a symmetry there. Libertarianism basically is very scrupulous about holding people to being consistent in what they say. So in other words, we say that you don't have the right to harm someone without if they haven't done anything to you. Mm-hmm. And if I do, then I'm violating their rights. But I do have the right to harm someone if they have initiated force against me. So you can use force in response to force, but only in response to force. So it occurred to me that if someone violates my rights, right, they use my property, my body, or my property without my permission, that's a type of trespass. They have basically admitted that they think it's okay to do that to me. So they're kind of laying down the principle that it's okay for me to do it back to them. So if I try to use force to defend myself against this person, or to retaliate against them, then the person that started it can't complain. So it's like this estoppel principle. So in other words, they've already laid down the rule that they've admitted that they agree that we live in this war of all against all. So they can't really complain coherently about me doing back to them what they did to me. So in principle, this would imply that, yeah, the eye for an eye rule, etc. I don't think it really implies that in practice for this reason. I look at it as more of a thought experiment to explain why we have rights, and to show there's a proportionality principle too. So if someone just barely slaps me in the face, but that's it, it doesn't mean I can shoot them and kill them, because that would be disproportionate. So there's a certain proportionality there in the response, but the response would be justified. But this thought experiment simply shows why anyone denying my rights is incoherent. And so that is a way of what Hans Hermann Hoppe shows too, that you basically can't have a coherent argument for socialism, or for initiating violence against people, or for violating rights. You just can't have a coherent argument. And my estoppel argument tries to show that too. Now, I think as a practical matter, as like people like Randy Marnett and others have shown, in practice, I think it would be, in most cases, far too impractical and expensive to literally have a private punishment system where the victims of crime get to go to this agency, and that agency would administer proportional punishment against the bad guys for several reasons. Number one, it would be expensive. Who's going to pay for it? Because in most cases, a violent criminal is not going to have a lot of money to pay you back. So someone's got to have to pay this private agency to do it, and it's risky for the victim and the private agency to administer this force against someone, because there's a possibility of mistake. So what if you punish an innocent man? Then what happens? Who pays for that? Then, do the jailers go to jail now? Do the punishers go to jail? And if so, who's going to give them insurance? And why would they get involved in this business in the first place? So I think in a libertarian society, it would tend to be heavily based upon restitution and ostracism, because that would be cheaper. It would give the victim, it would give the bad guys the chance to make apologies, make amends, make some kind of payment, and finally be readmitted back into society. And it would just work better for everyone. Now, in certain cases, of course, there's going to be certain people that are so irredeemable. And in that case, I don't think you're going to have an institutionalized punishment system, because it's just too expensive and too risky. But you could see on occasion the victim's family just hunting the guy down and shooting him. And then everyone in society would just turn a blind eye and let it go. Some people are just going to get killed because they're going to push it too far. And I think that's just the way it's going to have to be in some cases. I would think that would be a more workable system on the whole, probably less violent in the end with a libertarian society than this carceral state and the punishment type prison system that we have now, which, by the way, probably has 2/3 of the, half of the people in there are probably innocent of any real crime anyway. So, the whole system we have now is horrible.
And until what limits should punishment be restitutive, for example, a serial killer or something like that? And another question related to this is that if a person murders someone and the family of the person that has the right to execute the criminal forgives the criminal, the criminal should still be punished by society for his crime or not?
That's a tricky one. I'm not quite sure the correct answer to that one yet. My view is, the way I lean toward is this. It seems to me obvious that the victim's family have to have the first right to go after the criminal. And that implies that they have the right to forgive him, because that's one way that they can get restitution. You could tell the criminal, listen, in theory, we have the right to put you in prison for 25 years and make a little money off of your hard labor. But if you apologize and try to make amends, and you pay us some kind of money back for 10 years, then we will forgive you. In other words, they will use their right to punish and their right not to punish to bargain with him for some kind of payment. If a third party after could still punish the guy anyway, then the family would have no right to bargain. So it seems to me they have to have this right to bargain, which implies the right to forgive. Now, that said, I think that there are some criminals. The way I would look at it is this. Yeah, if it's a one-time crime against one particular victim, I think the victim family has the right to handle it as they see fit. But for certain criminals, we view them as what we call a standing threat. They're not only a threat to the person they harmed, they're a menace to everyone. And I just think if someone is so irredeemable and they're such a threat to everyone, then they should probably just be executed and killed, or at least exiled to some other country or some prison colony or something. Maybe for those people they would be put in prison, or maybe they would just be killed, because if you're bad enough to be put in prison, you basically are a danger to society. So I think certain people, like serial killers, people who have done repeated crimes, I think they can basically be killed by anyone, because they're a menace to anyone in their area. So that, I guess that's how I would look at. That's probably the best way to look at that.
Yeah, but where's the limit? Like, which person do we consider a standing threat? Some person that killed 20 people, 30, 15? I don't know.
These are the armchair questions that I think you can't deductively answer them. And it's not only because we don't live in a more private society where we have learned what rules have evolved. I think even then there's sort of like we know the extremes on the ends. We have a rough idea of justice about proportionality. Even the proportionality thing is not a mechanical limit. It's more of an insight, an intuition about the idea that the more harm you do to a victim, then the more you can be punished. But it's not really a mechanical, physical thing. So ultimately, you have to depend upon the sense of justice of the community. I do think that the basic principles that the private law has developed over time. Like, for example, common sense principles like, if possible, you shouldn't be a judge in your own case. In other words, you shouldn't take self-help into your own hands. And just, number one, there will be, we assume that there's some kind of legal system, and by and large, people will prefer you to go to the legal system because you could become a danger yourself if you just start taking law into your own hands. And you might be biased, and you might be mistaken, right? And you might overpunish because you're so angry. So by and large, I think people would tend to frown on their neighbors just taking the law into their own hands. Now, there would be exceptions for self-defense, like if you're at your home and someone breaks in, you don't have time to call your local security agents. You have to make a split decision, and people would understand that. But someone who's acting like a vigilante when they had time to let the legal system do its job might lose their insurance coverage. They might be shunned by their neighbors. They might be seen as an outlaw themselves. So I think that would be relatively rare. So I think if you have a grievance against someone who harms you, it's better to let the private legal system try to resolve it. And even if you disagree with the outcome, by and large, people are going to expect their neighbors to be willing to accept the verdict of a just legal system, because that's all we can do. And that's the only alternative would be everyone taking the law into their own hands, and that would lead to chaos. So I think there would be a disposition for people to be willing to compromise and to try to rely upon the law when they can. And they would be more willing to do this than they are now if there was a private legal system that was seen mostly as a fair legal system, not the kind of legal system that we have now.
Okay.
You would have to appeal to, if you have a jury of your peers, you would have to appeal to their common sense notions of morality and fairness and the context of what happened. And they would be the judge, and they would be a better neutral arbiter than you, because you're too close to it. And that's how the legal system would, I think, proceed over time. And then over time, when precedents happen and experience happens and customs start getting more entrenched in society, people start having a better and better idea of what the details of the law is, and they start getting a better idea of what a punishment would be, what the level would be, what proportionality is. And so over time, the law would improve, because it would be more and more detailed and rich and informed by custom. In the beginning, it would be rough justice, of course, 10,000 years ago or 200 years ago. But hopefully it would get better and better. Society would get more and more civilized, and we'd be richer and richer. People could afford better and better attorneys and lawyers and philosophers to help argue their case. And in that way, the law would be better and better and help serve human ends better and help reduce conflict more and more.
Yeah. So I strongly agree with you that the law cannot cover every scenario, unlike what Bloch says. Personally, I believe that common law and Roman law, when used properly, can be libertarian. However, you argued at the Property and Freedom Society for a kind of written code using an argument from Hoppe, and previously from Weber, against common law. Could you explain this, please?
Oh, I think I remember that. Okay, well, let me say a couple things. I'm probably less I'm more critical now than I used to be of this idea of the libertarian law code. I never was too into it, but like Rothbard had a few comments about and this is different than Hoppe's comment, but Rothbard had this comment about the law code of a libertarian society. He's almost a little like Walter Block on this. It's like they imagine, a judge in Atlas Shrugged sitting down and writing the libertarian law code. I don't think that's how law develops. Law develops incrementally over time, and again, you can't just sit down, have a philosopher, account for every possible thing that's going to happen. We have to wait and see, and then over time, the law builds up. The comment Hans made, which I agree with on there, it wasn't in favor of libertarian law codes. What he was talking about was the difference in the modern European continental civil law code systems compared to the common law systems in England. Because roughly speaking, libertarians admire the good parts of what we call the great private law systems of the West, which is the Roman law, which came before the common law, and which led to a variation of that in the European and in the Latin American civil codes countries. So the modern civil law countries are basically carrying on some of the legacy of the Roman system, and then libertarians also admire the common law system of England. Probably because most of the libertarian writers have been Americans or maybe Brits, they've been maybe a little bit biased in favor of the common law because they think it's an unwritten law and it evolves, and they don't really quite understand the history of the Roman law and how it's related to the modern civil codes. And they sort of think of the European civil codes as what you could call legislative positivism or legal positivism, because these codes are enacted as statutes. So they think of them like more like European central planning kind of. So Hoppe was simply pointing out that maybe this kind of arrogance of the common law libertarians is a little bit misplaced, and all he meant was that there's a lot of beauty and in the European civil codes, not because they're legislated, but because they were basically compiled civil law rules from Europe and also from the Roman law, which are easy for the layman to understand because you can just read it. It's like a little book, whereas the common law is scattered and all over the place. These differences are a little bit overblown because, first of all, in today's world, the common law is no longer only evolved, judge-made, evolved law. I would say it's probably 2/3 or 9/10 statutory law in America and in England. The common law is only a little bit core left of the private law, and it's continually being overwritten by all these statutes, which is just what happens in Europe. And in Europe also, the civil codes are still pretty good, but there's so many, European human rights law, the European Union, and then every nation has all these environmental laws which have nothing to do with private law. So I would say the core of the private law of the common law and the core of the private rules under the Roman law and is developed in Europe for centuries after the fall of Rome, those are still pretty good private law systems. And there are some advantages to the civil law system because they didn't have the history of feudalism, which they have in England. So a lot of the legal concepts of the civil codes are a lot cleaner and simpler and more streamlined and more elegant than the ugly and awkward, weird terminology of like feudalism, like the way property rights are considered in the common law with fee simple, all these lawyers understand it and the basic rules are right. It's not conceptually clean. So I think that was Hans's point, and I'm sympathetic to that. Being from Louisiana, the only civil law state in America where I learned a lot about the Roman and the civil law and appreciate it along with the common law.
Yeah, and in Spain we have a very good example of a very good decentralized law that is not anymore law, but is called fuero, and it was a very decentralized system with compiled codes of laws in different regions. So it was it was a very decentralized system. I think Rothbard liked it one time that he was in Spain, and I think that, but I mean, it was no common law. I mean, it was written. So I mean, it was a good example, and it was written. So I agree that common law. There is no reason to say that common law is by far better than.
No, I agree. And I mean, the main problem with the civil codes in Spain and in Greece and in Switzerland and Germany, in Italy, the main problem is that, like, the first article or two says the supreme source of law is the legislative will, because that's how they got it enacted. So they had all these legal experts who did a great job with their civil codes, and then the legislature just made them into a law. But that's really not a big deal. You know, in the common law, and I talk about this in chapter 13 of my book. In the common law, it's not like legal scholars and courts and even the laymen have no guide to what the common law is. They don't have to read like 17,000 cases. There are legal experts who write these books, which are like codes. They're not legislated, though. They're just like the American Law Institute's restatements of the law. And it's a good systematic summary. And then when you do that, sometimes some of the legal scholars notice inconsistencies between some legal decisions in the past 100 years or whatever.
In the wake of a full-scale war in Ukraine, 1 in 4 families faces poverty.
Is that you?
No.
Spivdia has aided over 2 million affected Ukrainians.
Hold on a second. Someone's
We
saying
aim to
something.
empower
I
vulnerable
think it's you.
people to rebuild their lives with dignity. Your donation today can benefit more.
Okay. Sorry about that. I don't know what happened. So there's a role for commentators, private commentators in codes, because then a judge might read this treatise and he'll say, oh, there's an inconsistency between these two legal rulings, and he tries to reconcile it and maybe gets rid of one of them. And so over the time, the law will improve at the urging of commentators. But they don't have any legislative power, which means they only have to they can only use their persuasive power and reasoning to try to persuade the courts. So it's a natural feedback loop. If you took the civil codes of Europe and you just made them private codes, it would still have the same usefulness to courts deciding disputes. They just wouldn't be legislated at all.
Yes, and in the case that I talk about, that you said how the codes in Spain, Italy, Greece are now, when, I mean, in Spain, the liberals were like the bad ones that wanted to centralize everything in the state, and obviously they with the supreme power of the state, and they tried to fight all the decentralized law codes that there were in Spain. So it was, the positivists in Spain, they were like the liberals that, they were like French revolutionaries, and they tried to centralize everything and finishing with codes that they were very close to private law, and they finished all of them or most of them.
Yeah, although I think it's a little bit futile. I've had people say, "Oh, why don't you legal scholars, you libertarians, write up the law code of a free society?" It's like, well, first of all, that sounds like a constitution, and that's not how you do it. And so I thought, well, if you really wanted to do that, you would just take, like, I don't know, the civil code of Italy or something, and just go through it and just get rid of the stuff that we think is incompatible with libertarian principles, but just use an existing code. Don't start from scratch. But even that would be pointless, because what's the point? It's just an academic exercise. If we ever gradually achieve a libertarian society, then people will start relying more and more upon private codes, private agreements in neighborhoods, insurance contracts, arbitration agreements and settlements between people. And over time, the law will just start using the parts of the private law, of the common law, or of the European civil codes, which are useful and compatible with libertarianism. They will be gradually adopted and become part of the new libertarian private law. You wouldn't need to have a committee of experts do it. And I think it's premature and futile anyway. And anyway, I'm not going to do it. I don't have time.
I understand.
Maybe you already answered to this question, but would the ideal be a charter similar to the Human Rights Charter, but a libertarian one? Or maybe a completely decentralized law?
Yeah, I think it would be mostly decentralized with regions of and again, it depends on how much of the world was libertarian. Like if there's only one libertarian region and everywhere else is statist, that's a different issue. But if you imagine a world of emerging freedom and more and more decentralized and more libertarian type approaches to things, which could happen if technology gets to a certain point where we become richer and richer and richer, in sort of, I'm gonna say a post-scarcity society, but like if we become far richer as a species, and we don't kill ourselves with nuclear war or something crazy, you could imagine that we don't abolish the state. We just, over time, we don't need it as much. Just like like in England, they still have the monarchy, but it's just a relic. They don't have any real power. No one really cares.
Just like in Belgium, in the Netherlands, Sweden.
Yeah. So if you imagine a future society of more and more peace, more and more wealth, more and more cooperation, then people will have their own healthcare. They'll have a robot in their basement. They won't need the government for healthcare. They might have flying cars, so they don't really need the government's roads. They don't need welfare because they can just grow food in a little machine in their backyard. The more and more things like that happen, they can educate their own kids with a robot AI teacher or something. At a certain point in time, people will say, "What do we even need the government for?" So let them go to hell. We don't need their centralized money because we'll have Bitcoin. Just over time they'll become a relic. That's my kind of hope, right? It's better than the alternative. So in such a world, I think you would have wide diversity of cultures and basic beliefs in these enclaves and these regions, and they would differ radically. Some might have age of majority be 14 years old, some might be 18 years old, some might be all religious, some might be secular, but they would tend to get along like by these international compacts, like if there's a dispute between two citizens of these two different nations, let's say, we need to have transnational law or international settlement or arbitration or something. And that would tend to be like general principles of law. We call that international law. So every country has different laws now. They differ widely from each other. But at the higher and higher levels you go, like on the field of international law, where there's like, say, roughly 200 nation states in the world today, all of different sizes and powers, but they're all considered to be sovereigns under international law. And they all get along under general principles of law, roughly the principles everyone agrees with, like, property rights and some human rights, and agreements between nations like treaties should be respected. That's international law. So it would be pretty abstract, but it would be the basics of letting these regions get along with each other, but then they would otherwise leave each other alone as for how their internal customs and laws form. I think by and large, we would understand people have the right to leave. Like if you don't want to live in this Mormon community or this Islamic community or whatever, there probably would be a general understanding of like human rights law. Like people have the right to exit, they have the right to leave. Just like you kind of have the right to secede in a sense by having your jurisdiction for most of the things you do. So I could see that happening in a future world, but it's hard to, of course, it's hard to predict.
No.
Yes. Related to this, I mean, there are like, for example, people who lives in communities that are very close, who lives, for example, I don't know, Orthodox Jews, Islamic communities and they live. I mean, it's okay if they don't want to follow these rules. But what do you think about, for example, religious law? I mean, in my opinion, as long as the religious law is not mandatory for people who are not members of this religion, is good. I mean, if everyone is forced to follow like canonical law or Sharia, is bad. But for example, there are a lot of criticism that, for example, in France, I mean, personally, it's not a good thing in general, the things that are happening with immigration, but there are a lot of people in some neighborhoods that has, for example, Sharia codes because they are Muslims, but the thing is that in theory is only for Muslims. For example, like, I don't know, Sikh tribunals in United Kingdom and or similar things, at least there are only for people from these religions. So what do you think about this religious law? What is the limit?
I think to the extent a society is libertarian, any kind of private convention like that is fine, but it has to, if it's going to be a liberal society and a libertarian society, basically human rights still can't be violated. So that means effectively these regimes have to be privately, voluntarily accepted by the people subject to them. Now, I know lots of these communities can ostracize you and you lose all your family and friends if you don't abide by it, and that's the price you might have to pay. It can be devastating, but at least that's a peaceful and a voluntary way to do it. Now, your earlier question though about child abuse, at least until someone's basically an adult. I mean, I think you could argue in certain communities, if the religious followings of their parents and the community they're in are so severe that it's tantamount to child abuse, then you could argue that gets to be a problem with violating the rights of the child. Like their parents might have the right to follow some bizarre customs of their religion, but there might be limits as to what they could inflict upon their children. If it gets to be so bad, I would say at a certain point, the child has the right to leave or to be rescued,
Yes, there is a big debate among libertarians with the, I think in English is circumcision, that, for example, Rothbard said, I think that Rothbard said that it was no licit, for example, but I mean, they justify like it's a part of the religious ceremony, and this, for example, in these cases, it could be like non-justified or yes or.
Yeah, I don't know too much about that, but I mean, I would say that I think that, yeah, like marriage and things like that ought to be a totally private and or religious matter. It shouldn't be a government thing at all, except, or not a government thing at all, but I don't know if it should be a legal thing, except that, the law ought to recognize if there's a co-ownership arrangement, like a husband and wife, but their status as husband and wife should simply be their choice before whatever ceremony they want to do. If they hold themselves out to the community as being married, then that has certain implications. In the law, we call that matrimonial regimes. In other words, the law, like in Louisiana and the civil law there, I'm sure it's similar in the civil in European continent. The law distinguishes between the marriage, which is the relationship, and the legal effects of it, right? And that's all the law should be. That's all the law should be concerned with, is that if two people decide to have a relationship of whatever kind, it could be two sisters living together when they're 80 years old, sharing expenses, or three people in a partnership or a domestic partnership, or some hippie commune, or a husband and wife, or two guys, whatever. Then if they choose to have rights with each other, like visitation rights in the hospital and guardianship rights of their children and co-ownership rights of their cars and their liability and their homes, then the law would simply just say, oh, these people have voluntarily chosen to pool their resources. So the law will recognize who the owner of this car is. The owner is A and B together. So they get to decide who uses that car, right? Because they're like a unit, like a corporation almost. But that would just be the illegal incidence of a private relationship. But that should be governed only by your religion or your custom or your or however you want to do it.
Now let's talk about you are mostly known for, your arguments against intellectual property and copyright.
Right.
This is quite straightforward. So could you please argue why it is not real property and why plagiarism should not be a crime?
Okay, a couple things. Technically speaking, the argument is not that intellectual property is not property. The argument is simply that when the legal system tries to set up rights in intangible things like inventions and in works of art or copyrights, it violates other people's property rights. Because earlier, the core principles of private law that libertarians favor is self-ownership of your body, and then ownership of scarce resources that you acquire either by homesteading it or by getting it by contract from a previous owner. Like, that's it. So that is fully sufficient to define who owns a given resource that's a resource that's potentially in dispute between two people. So if I have a car, if two people claim a car, then the legal system can answer the question who owns the car, because they can look at the history and the records and they can find, well, which one of you bought it from a previous owner? Yeah. It was me. So the other guy has no claim to the car. End of story, right? That settles it. So the property rules determine who owns a resource that's in dispute. And again, owning a resource like a piece of property or your body means that you can stop other people from using it if you don't want them to. They need your permission. But that implies that I need their permission to use their resource. In other words, I'm not permitted to commit trespass against them. I can't use their car or their home or their body without their permission. And if I do, I've violated their rights. But that means that I can do whatever I want with my own resources as long as I don't invade the borders of their property. In other words, the only thing I'm not permitted to do with my resources is to use them to violate your resources, right? As long as I don't do that, I've not committed aggression, I've not committed trespass, and you have no right to stop me from doing whatever I want with my own resources, right? That's the fundamental rule. That's what non-aggression means. That's what trespass means. That's why we have property rights. What that means is that if someone claims the right to stop me from using my resource in a certain way, if it's my resource, then they have no right to do that. You can't stop me from using my resource however I see fit unless I am trespassing the borders of your property. So if I'm shooting my gun across my yard into your house, yeah, I'm violating your property rights, and I can't use my gun to do that, and I can't use my body to do that, right? It's not because my rights in my gun are limited. It's because your rights in your property are your rights, and I don't have the right to invade them with any means whatsoever, even if I'm using a stolen gun. I just don't have the right to use your property without your permission. But as long as I'm not doing that, I can do whatever I want with my own resources, right? So the ultimate problem with copyright and patent law is it violates the original property rights I mentioned, like how you determine who owns what. You determine by who owns your body and who got the resource from a previous owner or by homesteading it from the state of nature. That's the full answer to determining who owns a resource in the case of a dispute. So in the case of patent and copyright, let's take patents. The government grants this license, this patent grant, to someone who applies for a patent on their invention And their invention simply means a way of rearranging their own matter that they came up with that they find useful. That's what an invention is. I'll get to plagiarism in a second, but the grant of that patent to someone gives them the right to stop me from using my factory to make a similar product. Like if you got a patent on a smartphone with rounded corners, like Apple had in the beginning, you can use that patent to prevent me from making similar devices.
Yeah.
Okay, but why do you have that right? Because, again, I'm not trespassing against your property, and yet you're using force against me, even though I haven't committed any kind of trespass. So that's essentially the problem with it. You can't own inventions. It's actually literally impossible. The problem with IP rights is not that information shouldn't be owned. It's that information cannot be owned. The only subject of property rights is tangible material resources things over which they're scarce resources, things over which there can be a conflict. So really what the patent holder is doing is he's using government force and the government courts to claim ownership of my factory, a partial ownership of my factory. He can't come in and use my factory, but he can prevent me from using it a certain way. Now, in the law, that's called a negative servitude, or in the common law, a negative easement. And that's commonly what people use when they have agreements with each other when they're neighbors in a neighborhood and they have certain agreements with each other, like a restrictive covenant, it's sometimes called a negative servitude. So basically, two landowners or 100 landowners that live in a given area can grant these easements to each other by contract. That's perfectly legitimate because it's consensual. So if I grant you the right to block me from using my home for commercial purposes, and you grant me a similar right, now we can all know that we can live in an area without a lot of commercial buildings. We just want homes in this neighborhood. So we kind of grant each other this negative right, but it's perfectly fine because it's the result of a contract. Just like a girl who consents to you kissing her, doesn't violate her rights. But if she doesn't consent, now you're committing assault against her, right? And what the state does in the case of patent and copyright is it grants these negative servitudes to another person, even though I didn't consent to it. Like ultimately, that's the problem. There's no contract. If I had a contract, it would be fine. But the state doesn't require there to be a contract. The state unilaterally grants the person applying for a patent. They grant them this negative servitude over my property. So that's effectively the problem with it. A second problem is, of course, the arguments given for intellectual property. The arguments are, for example, that it promotes innovation, or it's necessary for innovation, or without patent and copyright laws, there would be less innovation, or maybe even no innovation. The problem with that argument is, number one, it's false. It's completely false. There's no evidence for this whatsoever. And it flies in the face of experience and common sense. And number two, that's not how we justify law. We don't justify laws by saying, the government's job is to protect property rights and also to run around looking for
usefulness.
Well, looking for problems in the free market that the government can solve by patching it, by granting like we think that in a totally free market with private property rights, there's not going to be enough innovation because there'd be too much competition and people wouldn't innovate as much. So we would have an underproduction of innovation. So this is basically a type of market failure. So they think capitalism is pretty good, but it sometimes leads to market failure, and the government can come in and fix it by saying, well, what we're going to do is we think we have an underproduction of innovation because I don't have enough of an incentive to come up with a new invention if I know that you can compete with me very soon after by just copying my product. So we think that the free market is pretty good, but it's underproducing innovation because of this free rider problem or something. You hear this argument about pharmaceuticals and drugs all the time. And so the government's going to just grant a temporary monopoly to the guy that applies for a patent, and it's going to expire in about 17 years. Why 17 years is the right number and how they know this, no one has ever answered, ever. There's simply no evidence for what the optimal copyright term or patent term should be. The government just makes it up. And so the idea is that would stimulate more innovation than we would have, and so we're overall better off as a society because we have more innovation. But again, that's the function of law, is not to maximize innovation; it's to do justice and to protect property rights. And then within such a field, within such a system, people can innovate and compete and come up with inventions if they think it's worth doing or not. I mean, the government's job, the state's job, the law's job should not be to look for market failures and try to fix them. So that's another problem with the arguments for intellectual property. Now, you mentioned plagiarism. So there's another problem with arguments for IP, and that is most people don't understand IP because there's different nuances. Patents are different than copyrights. They're different from trademarks, and they're different from trade secrets. And all of this is different from contract breach, and all of that is different from plagiarism. Plagiarism literally has zero to do with copyright. Plagiarism is just a private contract breach or a code breach, like by a student at a university, or it's an etiquette breach by someone writing a book who doesn't give full attribution, or they quote someone without having permission. But it has nothing to do with copyright. And it's easy to see this because, for example, if I copy Shakespeare, one of Shakespeare's plays, which is hundreds of years old and not under copyright, there's nothing illegal or copyright infringement about me publishing Shakespeare's plays on Amazon or as my school term paper if I want to. Whether I put my name on it or not, if I put a Shakespeare's name on it, I'm just copying a public domain work. If I put my name on it, I look like an idiot, and no one's going to buy it. And if they do, then I just look like a dishonest person. But it's not a copyright infringement. By the same token, copyright has nothing to do with identifying attribution or credit or the name of the author. So, for example, if I were to copy, I don't know, Star Wars, one of the Star Wars movies tomorrow, or if I were to copy a Harry Potter novel, and if I left George Lucas's name on there, and if I left J.K. Rowling's name on her book, I'm not committing plagiarism. I'm not claiming to be the author, right? But I'm committing copyright infringement. By the same token, if I took J.K. Rowling's name off of the book and put my name on there, it's not like J.K. Rowling would be happy. She would say, "Oh, okay, he put his name on it, so now I can't complain." You see, has literally nothing to do with it. Has nothing to do with contract breach either. Has nothing to do with fraud. That's another mistake people think. They think that, well, if you sell a book with your name on it, that's fraud. Well, that's too glib and too loose of a definition of fraud. Again, if you think of the concept of individual rights that we talked about and property rights, and what contract law is and what property rights are, it's the power of an owner to dispose of their owned resource, which by contract, by giving it to someone else, by selling it to someone else. That's where fraud arises. If I have an exchange with someone and I misrepresent the nature of the thing I'm giving you for the thing you're giving me back, then I'm deceiving you as to the quality of the goods I'm giving you, and I'm basically getting your stuff for free or without your informed consent. So that's really what fraud is. Fraud is based on a type of trick like that, a type of a lack of informed consent in a transfer. It's not really about deceiving, about lying to people. So if I sell you the Harry Potter book, now let's say there's a world without copyright. So I'm perfectly entitled to sell a copy of the Harry Potter book, or I could sell a copy with my name on it, right? Just like I could open up a fake McDonald's restaurant and sell hamburgers to people, and McDonald's might not like it, but I'm not violating their rights. I could be violating my customers' rights. under a contract breach because they come in there. I'm telling them that I'm selling an authentic McDonald's burger, which implies that I'm authorized by the original, corporation. So I'm basically deceiving my customers. I'm getting them to pay me money in exchange for a hamburger that's not really what I'm representing it to be. So they could maybe file a claim against me for contract breach or for fraud. Mm-hmm. But that's just because I violated a contract with them or I misrepresent. And by the way, this thing is so unrealistic because if I spend lots of money to open up a fake McDonald's chain, eventually the real McDonald's is going to put on their website that this is a fake McDonald's. Don't go there. No one's going to go shop there because they're going to not trust me, and I'm going to go out of business, and I'm going to lose all the money I got from my investors, which means I never would have gotten money in the first place. And anyway, most people that start a new restaurant chain, they want to put their name on it. Wendy's put Wendy's on their chain. Burger King put Burger King on their chain. They didn't do it because trademark law forced them to. They did it because the new guy wanted to start his own thing and do a better job. So this is just a non-problem, really.
Okay, I agree fully with these positions, and then I have a question. Okay, some questions related to another topic, that is politics. And I mean, I noticed that you have collaborated with the new Libertarian Party in the US, and personally, I like the Mises Caucus. I mean, I believe that they are libertarians. There were like people who were not libertarians in the Libertarian Party, but I believe that they are libertarians. For example, people disagree a lot with them when they talk about, for example, not only decentralization, for example, against like accepting someone who is who wants, I mean, forcing like someone to accept people, and this is obviously a libertarian. And I mean, if you want to talk about the Libertarian Party and the new Libertarian Party in the US, and what do you think about?
And I've always been skeptical of politics. I don't know if that's the way to achieve. I'm more skeptical now than I used to be. I used to think that if we educate people enough, then that's how we achieve a free society. But it's pretty clear that we've been trying for 70 years to educate people, and most people don't care and they're not interested. I don't think that's how we're going to achieve liberty, by continually just trying to spread our message of liberty. Maybe some economic literacy would help, but even then, most people aren't interested in these kinds of things. So I think if we're going to have liberty, it has to come kind of from the bottom up, naturally. That is, without the Libertarian Party and libertarian activists being like, if we ever achieve liberty, it's not going to be really because of libertarians, except to the extent that a core of us have kept alive the ideas of classical liberalism and private law and economic literacy, Austrian economics, and things like that. I've never been a member of the Libertarian Party until about 6 years ago, when Dave Smith and Tom Woods and these guys joined. And we finally joined because the idea was, we're tired of the Libertarian Party calling itself libertarian, and most people in American life think of that. They think of the Libertarian Party as what libertarianism is. They're not really aware of the broader intellectual libertarian movement, right? And so the idea is that they've been sort of having bad candidates and kind of lukewarm policies for a couple decades now, and it's just giving the wrong impression about what our real principles are. So I guess we thought that if you're going to have a Libertarian Party, even if they'll never win, and they might win in other countries where there's a chance of multiple candidates, but like in Melee and stuff, because it's not a winner-takes-all system. Yeah, sorry.
Could you repeat what you just said 10 seconds ago? I think my Wi-Fi stopped for like 2 seconds.
I said that political parties in parliamentary systems, which is most of the rest of the world, they might have more of a chance of having some electoral success because, you know, you can, if they get 1/4 of the vote, they can still maybe have a form of government and have an influence. In the U.S., we have this winner takes all system. That's why we only have 2 parties, and the Libertarians will never win because we're not a minority and people don't want to throw their vote away. So I think the thing was, if you're going to have a Libertarian Party in the U.S., we want them to at least represent sound Libertarian principles, which is why the Mises Caucus got sick of the Libertarian Party's horrible take on COVID and all this stuff, right? And some of the horrible candidates in recent years. And so they won 2 years ago, and they and I decided to join, and I'm on the judicial committee there, and but as part of the Reno convention, we changed some things in the platform, and one of them I helped draft, which was kind of along the lines of what I talked about here earlier, is the most coherent and systematic way to understand our view of rights and property rights. And I'm glad that I got that in there. I didn't have time to get in intellectual property, and I don't really think it's necessary, because once you understand that property rights are identified by self-ownership, by homesteading, and by contract, then it becomes obvious that intellectual property is unjust, like the argument I just gave you. So it's sort of implied. So I'm glad that that's in there. I probably will resign at the end of my term in 2 years, because I think I'm going to not resign from the party, but I'm not going to be involved anymore. I don't think that's the way forward. I think my only hope is that we have candidates going forward who will at least be good spokesmen for our principles. Although, as you can see right now, the one that we chose shows that that's not going to happen in every case, because it's not Michael Rectenwald or Dave Smith, someone who actually has a clear understanding of property rights. It's this guy Chase Oliver, which is horrible. So it shows that the Libertarian Party is always going to just be a bunch of mediocrities, I think, and ineffective, and just a little club. So unfortunately, I don't think that's the way forward. But I'm glad that we, for some time, got some clear principles about property rights in the platform.
Yeah, and even though if the party would have a nice leadership, a good one, it's kind of hard in the Anglo-Saxon system, election system, because you have a majoritarian one. Well, the winner takes it all. Not like in the most of Europe, where it's a proportional system. So.
Yeah, I think even in England it's more like that. You know, parliamentary system. It's basically the U.S. I don't know who else has a system like this.
No, England has that system too. It comes from England, actually. Australia, New Zealand, almost all of the Anglo-Saxon countries have that system.
I thought I've heard of them saying they're forming a government. There's a coalition government, that kind of thing. But maybe I'm wrong.
Yeah. You can have a coalition government too in the US if you want, but nobody does that.
Well, because it's usually winner takes all. It's usually like
in the circumscription, the winner takes all the votes, all the representatives.
Yeah, whoever wins Congress gets to be the leader of Congress. They don't need to cooperate with the Republicans or vice versa.
It's not like in Spain or Germany, where if you, for example, I don't know, the community of Madrid maybe gives to the parliament, I don't know really, but let's say 50 deputies.
Right.
The winner doesn't take all the 50 deputies. Maybe it takes 30, because it's a proportional system.
Yeah, you have the Greens, you have the Christian Democrats,
the Social
Conservatives.
Democrats,
so,
well, in Spain, all of them are Social Democrat.
Different flavors. Okay, yeah.
Yes, but for example, sometimes there are good candidates in Republican, for example, Ron Paul. Now I have seen about another one that I don't remember the name, but he's voting against all the warmongers. He's a Republican. Massey, I think that is pronounced Thomas Massey. And for example, I know that most of the libertarians or the good libertarians respect Ron Paul, And I have a question now that probably I not answer, but is like for the association. It's about Milei. That Milei claims that he's a libertarian. What do you think? Do you think that is he's a libertarian like Ron Paul with uncorrectable principles, or he's more like Donald Trump?
I don't know. I mean, he talked a lot like an Austrian and an anarcho-capitalist in his campaign. He seems to rail against socialism. I don't know. I think he's not succeeding very much, but I don't know how much that is his fault, because I don't know the system there. He may just have limited power. Plus, I don't think he has a majority. I understand he has some ability to do a referendum, maybe if he needs to have some big changes, like reforming the dollar there. I mean, adopting the dollar or getting rid of the central bank. I know that some people like Hans-Hermann Hoppe are a little bit concerned about his being pro-Israel and siding with Ukraine and all this sort of happy talk. One of my friends, Oscar Grau, just wrote an article. I think he wrote a two-part article and then maybe a shorter version on Lew Rockwell, kind of criticizing some things about Milei. I think we need to wait and see. At Hans-Hermann Hoppe's Property and Freedom Society this coming September, there are two speakers who are going to do an assessment of him. It will have been about 10 or 9 months. So we'll have some ability to see what good he's done at that point. I don't see him being personally a big failure yet. And he has said some things that seem way more positive than most people, but I think we have to wait and see.
Yes, I know the work of Oscar Grau. I help it also like him, and I mean I think that the concerns are important also because I mean I know that with Milei there are a lot of fanatics only of Milei, not libertarianism, and they think that libertarianism is only Milei, and so there are a lot of I mean, there are concerns. I mean, I would have voted for him if I were Argentinian, and I mean, I obviously prefer him than another candidates, but the concerns are, I think, important because a lot of people like confused, and I think that about in politics because he went to Property and Freedom Society. One politician from Poland that he's libertarian, Corwin Mike, and he has, I think that except Milei, the biggest libertarian party in a country, Corwin Mike. I mean, and with this, I have a question regarding this. For example, Ron Paul was Republican, Corwin Mike, he's in the extreme right. And do you think that libertarianism, when it's inside politics, is essentially right-wing?
Yeah, that's a difficult question. I've never thought of it that way, really, because I've been focused on more the theory side, just the pure legal theory and justifying our rights and distinguishing us from conservatism and socialism or modern American liberalism. I've always thought that the conservatives and Republicans and the Democrats, kind of liberals in America, they all suffer from statism and one mistake or the other. I do think that the right, by and large, is less harmful than the left. And I've always said we're not right or left, but I understand, like Hans-Hermann Hoppe and others, arguing that in a sense libertarianism is essentially conservative, and I think in a way it is, in the sense of traditional values and natural hierarchies, because right now the government, the state, has taken over so many institutions that people get, rely on, like education and the arts, funding for the arts, and transportation, and so many things like that, healthcare, roads, education of the kids. Everyone is so used to that so I disagree with left libertarians who seem to be against authority and hierarchy per se. I think they're totally wrong. I think that if the state were to recede, there's going to be even more need for natural elites, natural authority figures, natural hierarchies to emerge and fill the gap and the void that should have been filled privately all along, right? So we need more of these hierarchies, and there's nothing wrong with natural voluntary hierarchies, as long as they're not coercive and they don't violate people's rights, right? So, so in that sense, I think the natural order of things for most people is conservative, in the sense that, private property rights that we believe as libertarians and as our political party, our political ideas, are there to complement the ability of private families and private neighbors to get along with each other and to live normal lives, which basically is conservative in the sense of traditional values: family, honesty, hard work, thrift, living a good life with each other. So in that sense, it's conservative and traditional. Doesn't mean that there can't be lots of diversity and variation in areas that are cosmopolitan and not traditional. But that's one reason why we would have, this is one reason Hoppe emphasizes that there's a difference between the free movement of goods and the free movement of people. Although in the past, libertarians used to think of them as the same thing. You have to have free trade and free immigration and migration. But his point is simply that, especially in today's democratic statist welfare states, that there's a difference between people and goods. You can have trade among goods, but when people cross borders, especially under conditions of anti-discrimination law and welfare and all this kind of stuff, it can lead to conflict. And then these people they're not just inanimate objects like a car. They actually have votes. They can vote, and they can change the cultural and the political makeup of an area. So given the existence of states, you can understand the concern with free movement of people, which is why we also need to have freedom of association, not hampered by anti-discrimination laws and government laws, so that people can live in their own little areas if they want to. If you want to go to New York and have a diverse melting pot, have fun. Some people want to live like in a culturally conservative, mostly Muslim or Christian area. They can live next to each other or nearby each other, and they can trade with each other and have some intercourse. But some people like to segregate. You see this all the time among different types of people. They segregate by language, by heritage, by cultures, by religions. That's the natural way of things, I believe. Now, I'm personally pro-cosmopolitan myself, very secular. I think I would prefer, by and large, to live among a diverse group of people. But some people are more conservative and more traditional, and I think that's the way to avoid conflict, is to let people voluntarily segregate if they want to.
Yeah, that's the beauty of libertarianism, that you can choose either if you want to have a multicultural melting pot like New York, or some Christian congregation in, I don't know, Iowa.
Yeah.
¿Tenemos alguna otra, Morena? No, ¿verdad? Okay. One last thing, Kinsella. I think the first question was not completely recorded, because I used two programs to record this. The Skype one and the one that it's already downloaded with Microsoft. And the Microsoft one, I think it didn't record completely the first question. So can we repeat it if you don't mind?
I can try. You mean about the nature of libertarianism?
Yeah, we can repeat the question. Don't worry.
Okay, go ahead.
Daniel will repeat it.
Okay. The question was about libertarianism.
Léela de nuevo simplemente y ya está.
That I have the introduction that, okay, regarding your last book, Legal Foundations of a Free Society, I would like you to start asking what libertarianism is and how a libertarian society will function, and if it's been anarcho-capitalist the same thing.
Okay, I'll try to recapitulate that. I don't know if you'll put this in the beginning or not, but for people listening, this is a kind of a repeat of my attempt at the beginning. I can't remember everything I said, but I think you were asking me about, which is basically the subject of mostly chapter, I think it's chapter 2 of my book. It's about what libertarianism is, like what is it? It's my own view, which I've arrived at over thinking about it. I used to say libertarianism is about the non-aggression principle, right? But the more I thought about it, I realized that is a shorthand for a set of property rights that the non-aggression principle refers to. But it's not all of it. It's only part of it. It's only the part that identifies your ownership rights of your body. So what libertarianism is I would say it's one of a number of political philosophies in the world. There's a lot of them. Libertarianism is unique in that it's the only one that completely basically objects to slavery. Every other political philosophy accepts a degree of slavery. Even classical liberalism and conservatism and neoconservatism, certainly totalitarianism and theocracies and things like that, they all have serious intrusions on people's basic rights because of their legal system, right? So most of them, all communism, socialism, most of them recognize a certain degree of individual rights. That is, most systems that are not totally, maybe North Korea is an exception, but most, even Russia and say France, they recognize a large degree of individual rights that are mirrored in the private legal systems of Rome and Europe and the English common law. And the core of libertarian principles is that we believe in the private law, private rights recognized by the Western legal systems, which is self-ownership of your body, which is why murder is illegal, because it's seen as a violation of my rights to my body. And then private property ownership of things that you acquire from the state of nature that are unowned, that's called homesteading, or that you acquire by contract from a previous owner, right? So those three principles, plus the idea that you have to compensate someone if you harm them and you violate their rights. So you might have to, so unless I commit a rights violation and a trespass against you, I own my body and I own the things that I acquired by contract or that were unowned in the state of nature. I own those things. That's what the property rights system recognizes, that I'm the owner of those things. And no one else can get it from me unless I voluntarily give it to them, right? Again, unless I harm them and I owe them some compensation. So then I might owe them some of my money to compensate them. So that's basically the core of Western law, but it's inconsistent. Most, even in classical liberalism and the original American founding, in England, in Europe, it's not perfectly consistent. So the state has the right to make exceptions for itself. So it can say normally robbing someone is a crime or murdering someone is a crime. But if the state does it, then it's not, so the state makes exceptions for itself. So it holds itself above the law. So then it can tax people, take some of their property. So you own your property unless the state says otherwise. So there are lots of problems with that way of, with the traditional concept of private law. It's just not consistent. Libertarianism alone, among other philosophies, number one, understand basic economics, supply and demand and Austrian economics to some degree. And we understand the nature of the state and the nature of laws, but we basically want we desire full consistency on these principles. So we don't want to make any exceptions. So the state doesn't get an exception. You know, unless you're a minarchist libertarian, which I would say is not a fully consistent libertarian, but they still will make some exceptions. So the state can still do things that a private owner couldn't do. Like the state may tax you to support a minimal state. So it'll be small taxation, but they still believe in that ability, which is an exception from the right of private property, the absolute right of private property right. And they think that the state can monopolize the provision of justice and outlaw other competitors, which is why it can charge monopoly prices and force you to buy its services. So I would say minarchists are not fully consistent, but the ones that are fully consistent, or they try to be fully consistent, are us anarchist libertarians who say that there are no exceptions or very few exceptions. So alone among all other political philosophies, libertarians consistently object to the right of other people to enslave you, to own your life, to hurt your body when you haven't harmed someone else. So that's really the essence of libertarianism, and it's reflected in our property rules, which is basically self-ownership of your body, the presumptive self-ownership. You can forfeit it by committing an act of aggression, but as long as you do that, as long as you don't do that, you haven't forfeited your right to your body, and no one has the right to enslave you, basically. And likewise, you have the right to peaceful possession of things that you own, that you acquired by contract from someone else, or that you found unowned in the wilderness that was unowned and you appropriated it. So that's basically the libertarian principles. And as my remarks indicate, I believe that a fully principled libertarian will see that, okay, so a fully principled libertarian supports private property rights because we oppose conflict and conflict among people, and because we oppose aggression, that is using someone's resource without their permission. The reason we support these property rights is because we oppose of these things. And I forgot where I was going with this. And so because of that, so we oppose aggression, which means the violation of people's property rights. So that means we oppose private aggression, crime. Effectively, we oppose crime. Crime is the lack of respect for people's property rights. That's why we oppose it. That's why we favor property rights. But that means that we oppose all crime. But we also recognize that there are different types of crime. There's private crime, which is crime done by private individuals or private organizations like mafias or things like that. And then there's what we would call institutionalized crime. That is when you have a state emerge. That is another source of aggression. Because the state necessarily commits aggression because it has to either outlaw competition, which is an act of aggression, or it taxes people and forces them to pay for its services, which is a form of aggression. And so we libertarians that are consistent, we oppose private crime, but we oppose institutionalized crime or the state. And because the state cannot exist without committing one of those two types of things, and usually both, then we have to oppose public criminality, which is the state, and also private crime. So that's why a consistent libertarian is an anarchist. And as I mentioned in my earlier remarks, my view is that anyone who claims to be an anarchist but is not a libertarian anarchist. So I would say every consistent libertarian is really an anarchist. That means an anarchist libertarian. But I also think that people that call themselves anarchists that are not libertarians are not true anarchists, because unless you support private property rights, which is what libertarian anarchists do, then you support people being able to take other people's property in this anarchist state, even though they haven't committed aggression. And that's inevitably going to lead to powerful groups like the state speaking on behalf of the people and committing mass crime like every state does. So I think that these other anarchists are fake anarchists. So that's how I view anarchy and libertarianism, and that's what libertarianism is. So libertarianism is the consistent application of private property rights with no exceptions.
Yeah. Well, I will finish hear the interview, okay?
Okay.
Bueno, pues muchas gracias a todos por ver nuestra entrevista. Bueno, pues muchas gracias a todos por ver nuestra entrevista y os esperamos otro día más. Okay, I'll stop here.